Well, Lords, if it may please the Court, I'm Andrew Parker and my learned friend is Emily Green. We appear on behalf of Shazam Cars, the appellant in this case. There are two submissions we'd like to make. The first is based on the underlying proposition that causation in economic tort is to be distinguished from that in breach of contract. The authority to be applied is Lumley and Guy, 1854. By holding that the respondents' actions were insufficiently causative of their father's breach of contract, the Court of Appeal has misconstrued the nature of liability under economic tort. We argue that this is a very different species of liability.
There would be no breach without the inducement. OBG and Allen is clear that there is a parallel to be drawn between inducing breach of contract and circumstances in which the defendant becomes liable as an accessory. There are three main causative points to be made. The breach of contract and economic harm was inevitable, which we would say is evidence the respondents intended or were indifferent to the economic harm caused. A deliberate choice had been made to act in breach in full knowledge of the consequences, and but for their acceptance of their father's assistance in full knowledge of the breach would not have occurred. The respondent's participation was therefore a wholly causative and necessary precursor to the father's breach of contract.
So,
I think go for the conclusion.